Hey, it's 2 o'clock on the dot. Well, according to my clock. So good afternoon, everyone, and welcome to the AI Ownership Dilemma webinar. I'm Tharusha Naidu, and I'll be your host for today's discussion. Just to a few house rules before we begin. The recording of the webinar will be provided to all registrants, so not to worry, you will receive a copy of the webinar recording. And right at the end, or towards the end, there will be a poll put up, so just look out for that. Okay, firstly, I'd like to thank you all for taking the time out of your busy schedules to join us for this session. For this webinar, we'll be focusing on how artificial intelligence, better known as AI, intertwines with intellectual property, a theme that has grown increasingly relevant with the rise of AI-generated content. Before we delve into today's topic, I would like to introduce our esteemed panelists. First, we have Ms. Verena Griffiths. With over 15 years of litigation experience, Ms. Griffiths is a well-established attorney and trademark practitioner at Adams & Adams. Her keen interest in copyright, software, and publishing has led to a wealth of experience in IP enforcement across various African territories. Next, we have Mishandran Naidu. Mishandran is currently a researcher at the University of KwaZulu-Natal's Health, Law, and Bioethics Department, focusing on the intellectual property implications of disruptive technologies, especially in the public health sector. He's made commendable contributions to global conferences and is paving the way in biotech innovation in South Africa through his PhD research. Thank you both for joining us today. As we progress through the webinar, I'd like to remind our attendees to submit your questions in the Q&A box, and we will have a dedicated Q&A segment later on once our panelists have gone through the points of discussion. We are keen to address any queries or thoughts you might have. With introductions in place, let's set the stage for our first segment. Starting off, we would like to look at the, have a quick refresher on intellectual property, looking at copyright, patents, trademarks, and trade secrets. So I'm handing over to Verena to discuss this for us.
Good afternoon, Tharusha. Thank you very much, and afternoon to everybody joining us this afternoon. Thank you for doing so. It's my pleasure to be here and share some of my knowledge on the topic with you. So just briefly getting back to basics around IP, what is it? Intellectual property is really an umbrella term for a set of intangible assets that come into existence following a creation process undertaken by humans, typically. So the forms of intellectual property include patents, which very broadly speaking would protect inventions. Then we have designs, and they protect the appearance of articles. We have trademarks that protect typically brands and branding elements. And then we have copyright, which protects the material creations of human intellect, human technical skills, creativity. So anything that comes into existence in a material form following that human skill, effort, creation process is protected by copyright. And it is really in this field of copyright where the questions around content generated by AI start arising. You know, the content that is generated in this way is typically the kind of thing that copyright would protect. So the questions then, can they be protected? Are they protected? And if they are protected, who owns those rights? You're on mute, Tharusha.
I'm terribly sorry about that. Always happens. So I was just saying, like, let's now look at the current state of AI in terms of its capabilities, advancements, and relevance to intellectual property.
I think around the technical perspective, I'm not even going to hazard a guess. The development is just running at such a pace that to try and pinpoint it would be extremely difficult. But what I do know is that AI is nothing new. It has been around for a very long time. And the way I understand it, at least, is that it is really any technology that is designed to match or even exceed human capability. So we have been engaging with this technology for many years. If you think of something like a recommendation system, Netflix telling you what you want to watch, predictive text, understanding human speech, something like Siri from Apple or Alexa from Amazon, all of those have been built and use AI technology. So it's not new, but what has happened is that AI technology, and specifically generative AI in the form of large language models like ChatGPT and diffusion models like Stable Diffusion, they have been, for want of a better word, unleashed and made available to the public at large for free. So we're now in a situation where the availability and the accessibility of this technology has just grown exponentially to anyone who has an interest in using them, playing with them for any reason. And that in turn, has sort of sped up the development, not only the development, but we're seeing enhancements to these technologies, so that it's just we're almost caught in this runaway train situation and trying to interpret what this all means for intellectual property and intellectual property rights.
Yeah, interesting that you mentioned that AI has been around for a very long time now, and it's just that it's only getting the attention that it is now due to the ChatGPT and large language models that are now being unleashed, and also just like punted heavily. So following from that, I think now we can really ask the question, if AI has been around for this long, why has it not been regulated? Or why have we not looked at in terms of who owns AI created content? And is there any case law that we can look to for guidance on this?
Trisha, again, very good question. If you ask, like I say, it's like we've been caught by this runaway train, and suddenly we deer in headlights trying to figure it out, and it has not been anything new. But we're not completely without guidance. Let's look at the question around ownership, and we're talking about ownership of material that is produced through AI platforms by using the AI technology. So typically, the user putting in a prompt and receiving something in return, which let's call it the end result. So can that be owned? Can the rights, intellectual property rights in that be owned? And if so, who owns it? I want to preface that conversation by saying the considerations around copyright ownership, at least, is complicated by the fact that copyright is a very technical subject. There are various factual inquiries that need to be assessed before a conclusion can be reached, and therefore it's not really possible to sort of give certain answers, certainly not by using sort of a broad brush approach. Everything will depend on the circumstances of each case. Another important point to bear in mind is that copyright, at least traditionally, protects creations of the human mind. It's a human author's intellectual skill or technical skill or creative effort that results in something protectable. And what happens with artificial intelligence, as we know, is that, of course, the human author is replaced by the technology. Now, if we take it back to the traditional position under copyright, where a human produces something that can be classified as a copyright work in terms of the Copyright Act, that is protected automatically the moment that it is created, provided that the author has spent enough own effort and skill, and meaning that the work wasn't slavishly copied from something that's already in existence. So where we now face this issue of, we used to working with assessing a human author and what he or she has done in producing the end result. We're now having to look at this technology and trying to figure out whether what it produces could at all qualify for copyright protection. The US, for instance, the Copyright Office in the US has come out very strongly. The issue has been crystallized, at least to my mind, to say that where there is no human author, there can be no copyright protection for material created by artificial intelligence. In the South African context, however, we have a provision in our Copyright Act that stipulates that a work that is generated by a computer-generated work can be protected by copyright. And our Supreme Court of Appeal has already held a number of years ago in a case relating to computer software that computer-generated works are works that have no human authors. So we're in this position where we already have recognition in our legislation and our legal precedent for works that have been created by computers, in this case, artificial intelligence, where there is no human author. And then we're also in the privileged position that our Copyright Act tells us who to look to in terms of the author, identifying the author of a computer-generated work. The Act simply says that the author of a computer-generated work is the person who made the arrangements that were necessary for the creation of the work. So you can see we've got a factual inquiry there. We need to determine who the person was that made the arrangement that was necessary for the creation of the work. And if you consider that question, then you'll see we come up against either the developers of the AI technology, the platform, or we come up against the user that inputs a prompt that then generates an end result. And therein lies quite an interesting conundrum, because without the development of the AI tool, the technology, the work, of course, would never have been created. However, the developers of the AI tool cannot even envisage what all can be created. They certainly have no intention to create what the user is, asking the AI to perform. On the other hand, we have the user, who is the person putting in the prompt, that could then be considered as the person making the arrangements necessary for the creation of the work. So we have these two sort of opposing options, I guess. And either way, whether you're arguing in favor of the developers of the AI or whether you're arguing in favor of the user, because really at the end of the day, without the user's conceptualization, I guess, of what needs to be created, the work also would not come into existence. But whichever one you are arguing in favor of, you still need to meet the requirement of originality under South African law, which means you need to have expended sufficient skill and effort in the creation of the work. And again, we're faced with a factual question. And it will really take a close interrogation of what was done in any particular circumstance. What exactly happened? What did the user put in, or what happened in the creation process, in order to test that theory of whether enough personal skill and effort has been expended by the author. To my mind, at least, there certainly should be a difference between somebody putting in a couple of words as a text prompt that then generates an artistic image versus, let's say, a team of creators sitting down with something like ChatGPT to write a piece of code that underpins a mobile application where it's more than one person working together and engaging with this AI tool, sort of assisting, correcting, and giving feedback, and until they reach a point where they are satisfied with the end result. I'm not necessarily saying that that would be enough to meet the originality criteria. I think the point is that there is a distinction to be made, and we can't necessarily draw a line in the sand to say, yes, it's possible and the user will own, or no, it's not possible, that these types of works created through AI platforms won't be protected by copyright. It's going to take a factual inquiry and a factual assessment in each case on its own. Now, you mentioned potential cases. What we haven't seen, well, most of the examples are, of course, are coming out of the US, and there are 1 or 2 in the UK that I'm aware of. Locally, we haven't really seen much. There's been one on the patent side. But what we're seeing, well, the first set of examples coming out around these issues and around these questions under copyright has definitely been from the ownership perspective, in terms of users claiming ownership rights, and specifically copyright ownership rights in what was produced by the AI platform. One such example is from the United States, and it entailed a comic book. So we had an author who created a comic book. She wrote the text for the comic book herself, but for the artistic images, she used one of these generative AI platforms. It's called Midjourney, where you insert a text prompt and you receive an artistic work as a result, or as the end result. So she had used Midjourney to create all of the artistic works for the comic book. In the United States, you can register your copyright. So you make an application to the US Copyright Office, and then you claim your copyright. And she claimed copyright over the text, but also the artistic images that were rendered through Midjourney, and then also the published edition. And the published edition is really just the collation, the layout of the entire comic book. And so the real issue arose, or the dispute really over the ownership of copyright arose around the artistic images that were not created by the author herself. Now, her evidence was that she did not only put in one text prompt and received back an image. She said that she pushed back on what she had received by changing the text prompts slightly, or going through various renditions thereof until she received something that she was happy to use in her comic book. And then on top of that, she took the images that were generated by Midjourney, and she used the tool called Photoshop to edit the images slightly until she was absolutely happy with what went into the book. Now, if you look at, because she had to submit these as evidence as part of the application for registration, if you look at them and you compare what was rendered by Midjourney and what she had as the final result post Photoshop application, there wasn't really much difference in those two images. So what the office considered was really the images as Midjourney had produced them. And the office equated what had happened to providing an artist with an instruction. So had the author of a comic book provided an artist with an instruction to please create these images for my copy, like any illustrator, and the artistic works return, then certainly you won't have a claim for copyright ownership over those artistic works. The artistic works, the copyright in the artistic works would stay with the artist. So it's not the same as putting a tool like a paintbrush in the hand of an artist. It is, one step removed. And so the office was willing to grant her the copyright ownership in the text and even in the published edition as a whole, which contains both text and images. But as for the images on their own, the Copyright Office was not willing to grant her copyright ownership over those, finding that it was created by the AI platform, which makes independent decisions in the process, is not influenced by her at all, and in the absence of a human author, it was found that there can't be any copyright protection over those images. So, from assessing sort of an ownership perspective, that certainly has been a very interesting case to follow and an outcome to see.
Certainly. Okay, so that interestingly enough, that there is guidance out there, and we can look to our international jurisdictions in terms of what is advancing with AI generated content and copyright specifically. Let's now look at something a lot of people might be curious about, is the potential infringement on other creators, and what are the potential solutions to those infringements and the implications?
Sure. The question around infringement is actually quite a difficult one, and the reason for that is that in order to assess infringement of copyright, and especially in this environment, it will, once again, it will be a factual question. You will have to look at exactly the circumstances in front of you. But what will be very relevant here is to get to grips with and really understand the specific technology that one is dealing with in a particular case. These AI models, they work on the same broad concept in terms of training artificial intelligence to then, generate content, but they don't use the same models within those platforms. There are different kinds of models involved. And so not each and every sort of creation process will follow the same path. And for that reason, again, we can't sort of have one size fits all an answer. So it's difficult to get into those details, but a general comment that will definitely hold true is that many of these existing AI platforms are or were trained on publicly available information. And when I say publicly available information, I'm talking anything and everything that has been published on the internet, right? So large data sets are gathered or were gathered that are then fed into the AI systems and used to train them. And those data sets are built by scraping images and text from the internet. So the first thing to understand is the mere fact that something is available publicly does not grant an authorization to do something with that work that would otherwise be excluded in terms of copyright principles. So something that would constitute a copyright infringement over any type of work, it's still the case even though the work has been made publicly available. And it's not a difficult concept to grasp. I think of a library. Books are there, they're publicly available. It doesn't entitle you to grab a book and make a copy, not at all. And it's the same holds true for the internet. So the mere fact that these material is available online and can be accessed does not equate to an authorization to do something that would otherwise be illegal. So any form of reproduction, and that's just plain copying, or adaptation, and adaptation is really, you can think of it as a form of copying but making adjustments. So it's not exactly an exact replica of the original, but the original is still recognizable. So any reproduction or adaptation of something that is protected by copyright without the consent of the copyright owner will amount to copyright infringement. So to my mind, at least some of these AI platforms have committed copyright infringement on a phenomenal scale. And hence we are seeing litigation. There is litigation pending in the US, there is litigation pending in the UK, from authors through to big companies, saying they have identified their works within these data sets. The works were scraped off the internet without their authorization. They were reproduced or adapted. Therefore, copyright infringement has occurred. So that is all around the input data, right? The collation of the data set that was used to train the AI. The fact that the works used in that process may well be protected by copyright, and the use thereof in these systems, therefore unauthorized, therefore there could be infringement. But there's a second area of risk, and that is, of course, with what is generated and being put out by the AI platforms. Could there be a potential for infringement there? Now, as much as these technologies are intended only to learn from the information that they are provided, so they should learn from and train on these data sets, and they are not necessarily intended to reproduce and so just spew out on the other side exactly what has been fed into them. That's not how they are intended to work. I don't think that the possibility of something being generated sort of as is, being reproduced or adapted, and that is the result that is provided on the other side of the generation process, I don't think that can be excluded. I don't think it can be guaranteed that what is produced by any AI platform is 100% new and does not contain any reproduction or adaptation of existing works. To the contrary, one of the cases pending in the UK involves the database of Getty Images, which is a very big sort of image-based depository business. And they could show that some of what was generated by the AI even still had the watermark on it of the original Getty image. So, that just shows you that as much as yes, the technology is not designed to work that way, it could still happen. And so the risk that arises is that where users of these platforms are receiving results that are generated by AI, we cannot exclude at this point in time the possibility of that constituting an infringement of some existing work. And, to then take something like that and put it out into the market for commercial use, at least, I think, could create significant risk for the user, especially if it's something that's sort of aimed at a large scale exploitation. So it's definitely that risks exist on either side of the spectrum, from input to output. On an infringement question, I think that those risks are certainly there. And then turning to your question around what could potentially be the solutions here, maybe I tie this back to your comment a little earlier about why haven't we seen these issues being regulated just yet. We're probably aiming, I would say, for either regulation or maybe even legislative amendments to sort of clarify and put the boundaries in place to give us all the lay of the land, the playing field, so that we have more certainty over whether are these works protected, if they are protected, who owns them, when do issues of infringement arise, and so on and so forth. We know that any type of regulation or legislative amendments take a long time to get them through. We know that looking at our own copyright amendment bill, it can get hugely contentious. We know that political issues come into play. So as much as regulation and legislative amendments are probably necessary, it's also likely, at least in my opinion, that it's locally, at least, it's probably some time off. My personal expectation is that we might see something sooner in terms of the big role players starting to talk about contractual arrangements, much like we saw after the onset of the large-scale online music piracy scenario, that was so prolific at one stage. Yes, there was litigation, but then the big role players came together and they came to contractual arrangements around how do we protect the interests from both sides. So I'm expecting possibly something more along those lines. We're seeing it in the Hollywood strike at the moment. The writers, resisting the use of AI in writing scripts, the actors resisting the use of AI in generating images. So a lot of pressure in the industry, and the way out of that is for the role players to come together to say, right, this is how we will or can use AI, this is what we can't or won't be doing with it. So I'm suspecting that maybe something in that direction, maybe, a complete open source environment on the one hand versus a licensed environment on the other, where authors and artists could potentially agree to share copyrighted content into those models, let's say in exchange for some sort of royalty fee, so that yeah, so that the interests, like I say, from all sides are perhaps regulated by agreement. And that's how I see it.
And just whilst we're there, do you think that this that could also be addressed in a retrospective manner? Because like something with ChatGPT, where they do mention that their data is up until 2021, if I'm not mistaken. So you know, from that point onwards, they don't have any new data going into those models. So how would that work in terms of retrospective regulation?
I think that's going to be very difficult. And you know, what you're hinting at is sort of the damage is done, and I think that's correct. Where the stuff has been used, the material has been used. I know of authors and artists that have called for the removal. They have been able to identify their works in, you know, at least one of these very big data sets, and they have called for the removal and deletion of their works from the data set. And the company owning the data set just says, you know, they can't remove it because the way that it's very technical. The way they had shared it with the AI platform did not entail a reproduction on their side. So they have nothing to delete from their system. And the AI platform, on the other hand, you know, the AI has been trained. It's seen that material, it's learned from that material. So sort of what's been seen can't be unseen type of a scenario. So I think that will be very difficult. I think a lot of that might come out of the litigation in terms of what has already been violated. Will there be findings of infringement on that? And will they, you know, potentially follow, will there be sort of interdicts or damages claims that follow on from that? And that will dictate probably the way forward. But I think to try and claw back what has been done is going to be extremely difficult, unless there is a way to mitigate it through contractual arrangements. But I guess that will come down to bargaining power at the end of the day.
Definitely. Thank you. Some great insights there. Okay, so halfway into the webinar, I think it's time to bring Mishandran in. And Mishandran is going to talk around a little bit more on the technical side of ontology, and also in terms of how can various aspects of regulation ensure that it's maintained and effective governance in light of AI. So handing over to you, Mishandran.
Thank you so much, Terusha. And thank you so much, Verena. That was really insightful as well. So I must apologize, my voice isn't carrying so well. I am quite ill at the moment, but I will do my best here. I have prepared a slideshow just to save some bandwidth. I will stop my video and share this now. There we go. Yeah, okay. So what I will be speaking on is basically, I'll just give you guys a bit of the history and the philosophy of intellectual property law. I think that has been, well, it has been a large focus of my particular research as being an academic in the intellectual property space. And I think it'd just be really interesting and facilitate this conversation and just further thinking about these issues if we reconsider, you know, the actual origins of intellectual property, their foundations, and are there any clues there that we can obtain and how to actually solve some of the issues that we're facing today, some of the issues that Verena, for example, mentioned. Okay, so a brief history of copyright and patent law. So this goes back to the 11th century in the UK, well, particularly in South Africa, we trace back to the UK intellectual property law. At the time, it was a feudal system, of course, you know, the UK was ruled by the Saxon kings at the time, and the feudal system entailed basically that any persons living on the land would have to pay penance, stipend, rent to the actual kings of the land. So if they lived on the land, if they produced anything on the land, or any artisanal products that they produced from the land, they would have to pay a certain amount to the king as rent. And eventually, after some time, they started to rebel against this, and they started to lobby against the kings for basically just the independence and more rights. And this eventually resulted in the Saxon kings granting each independent town or borough, it was known back then, with charters, basically. So they had their own general corporate organization, which was governed by a charter. And these chartered companies were known as merchant guilds. So merchant guilds were basically just sort of early corporate organizations which controlled trade, regulated trade, and also dictated specifically the actual conditions of trade. So who can trade with who? What can you trade? What is the price of trade? Which towns can trade with each other, etc., etc. And people of the guilds were known as guildsmen. People who did not belong to guilds were known as non-guildsmen. Importantly, non-guildsmen were actually not allowed to produce any products at the time. And if they did produce anything, they would have to sell it to guildsmen themselves. They were also not allowed to buy any materials to produce certain goods. As time went on, these guilds sort of became a lot more powerful and a lot more intertwined with the town itself. It became indistinguishable between what is a guild and what is the actual governing body that regulates the town. Interestingly enough, at this time, there wasn't actually such a thing as an author. Any writers at the time were just known as proprietors, and what they actually owned was the corporeal form of the manuscript that they had in hand. So they owned that actual physical copy. And what came along with that physical copy was a personal right of first publication. This was known as the incontrovertible principle. And what writers at the time would do was basically they would either get paid or they would request patronage from certain guilds in order to fund their writing experiences, or they would also get paid in terms of different things like fame or other sort of benefits. And if a guild were to give a patronage to a proprietor at the time, what would happen thereafter, after the completion of the work, the guild itself would then be vested with the common law copyrights. And this was just a publisher's right, or a guild's right, actually, to be more specific, and not an actual author's right. And excuse me. Yeah, and so with the invention of the printing press, things actually really became topsy-turvy for quite some time, because the invention of the printing press spurred mass copies of various valuable works in the UK and outside the UK, particularly in Scotland. So the guilds in the UK were sort of, not sort of, but actually just very threatened by what was happening on around them, because they felt that, you know, they don't have control of these valuable works, yet they have a common law copyright in these valuable works. And so they started to lobby against these. This was actually the birth of what we know as pirates today. Pirates was a term reserved for the Scottish in particular. So they started to lobby the crown basically at the time, and they were lobbying for stronger common law copyrights. And in this period as well, Lester's patents also started to be developed. This was in the 1500s with the Clerks Act in 1535. And what the crown would do at this point was basically sort of grant a charter to specific guilds for regulating specific types of works and using the guilds in such a way that they could control what kind of works would be published, printed, or basically just distributed. This was important because at the time there was a Protestant uprising. Of course, Protestantism is about basically essentially that you don't need to go to the clergymen to get a meaning or understanding about the Bible. So each person themselves can interpret the word of God for themselves. So basically the guilds at the time were used just as a means to control the narrative and to suppress what was known as heresy at the time. So inventorship. The inventorship doctrine in patent law has actually spurred a lot of the debate since 2020, which is when the first case law relating to an artificial intelligence system called DARBUS came out. Basically, a guy by the name of Stephen Thaler, Dr. Stephen Thaler, developed an AI system, and he then listed that AI system as the inventor on a patent, with Dr. Thaler himself as being the applicant. And this necessitated a spur of challenges, particularly in the US, the UK, and Australia. Each of those jurisdictions actually rejected the fact that an AI cannot be an inventor, and therefore the patent application must then lapse, meaning that you cannot have any patent rights in the created idea simply because it was a misdirection as to the inventorship status. You cannot list an AI as an inventor simply because patent law or intellectual property law as a whole serves human inventorship or human creatorship. And an AI is certainly not a human, nor does it possess any legal personality in order to transfer those rights, the rights of application for a patent, to a natural person. So the true and first inventor test really came from the Statutes of Monopoly, which was developed in the 1600s, I think 1608, by Sir Edward Coke, who was a jurist at the time and then became the Chief Justice. And he developed this act essentially as the first codified form of patent law because he wanted to really limit the powers of the Crown, because at the time the Crown was using letters patent as a means to control trade, but also abused the way in which letters patents were granted so as to ensure that favor was given to basically favorable persons, so the knights, etc., etc. And this was very bad for the economy of the UK at the time. And so this act was really there to limit the powers of the Crown, but it was also there to facilitate economic welfare and also to encourage persons to come into the UK and to invent, knowing that there will be protection afforded to you here for a certain amount of time. And the thinking was that if you were to grant persons protection for their inventions for a specific amount of time, they would then stay in the country for that specific amount of time and pass the skills of the trade on to other persons within the country. So it doesn't matter if they then leave back to their country afterwards, the skills itself would still be situated within the country and the country can then develop further. And one of the things that have come up in the cases and a lot of the academic literature as well is the link between inventorship and conception. Again, inventorship goes back to the idea of human creation. Conception in patent law is what describes the human element of it. Conception is understood to be this mental formulation of the inventive idea, which is contained in the actual claims of a specific patent application. And the argument is, of course, that an AI cannot conceive of an invention nor its claims in the same way that a human can, which I think is a very difficult argument to really make, because quite frankly, it's really just pattern analysis and pattern demonstration, which is just Bayesian inference. And yeah, so, but interestingly enough, the questions around inventorship also don't really take into account that who really conceives of the invention isn't really so much the inventor themselves, but more the innovators. And the innovators are usually the patent attorneys, the patent agents, because they are able to specify particularly how phrasing or how an invention should be worded, what should be left out, what should be focused on, what should be included in order for a patent to obtain. So it's not necessarily correct to say that, well, we afford the rights only to inventors. The inventor is the starting point of a patent. Therefore, we cannot allow an AI to, be able to transfer the rights to an applicant, a human applicant, because the inventorship is a start of the right, because it isn't necessarily the case. Inventorship is also something that's not really tested, particularly here in South Africa, where we don't have a search and substantive search and examination system. But also overseas, inventorship is something that's left for any oppositional parties to actually critique. So what would happen is any applicant would just apply, it would go through the necessary procedures, examination, etc., etc. And if there's any questions relating to inventorship, say an opposition party contests this and says that I was not included or you're not the inventor of this, then would have to then go to court and they would have to, or they can have opposition proceedings as well. And that would have to be contested and led by an evidentiary burden to determine retroactively who is the inventor or who are the inventors and what are the inventors' rights. So it's not really something that's determined in present day. It's more of a retroactive positing. Okay, so continuing from when I spoke of the history of copyright and patent law. So around the 1700s was really the birth of the Enlightenment. It really started in Scotland, actually, Scotland and France. And this was really the birth of the open society. So what happened at the time was the Enlightenment thinkers of the time really didn't want the church or the crown at the time to keep all of this information, particularly religious and cultural information, behind bars and kept under these veils of secrecy. Nor did they want the crown to continue to restrict the flow of information, data, knowledge, etc., etc. And so what they did was they said, well, we're going to bring out all of this information and knowledge because it's necessary for society itself to persist, to develop, to grow, and to ensure that conflict resolution can take place. So I've mentioned Protestant and Luther as well. So Luther was a thinker, a Protestant thinker. This is also the birth of the scientific method. So the scientific method was basically an idea at the time that, you know what, back in the 1700s, before the Industrial Revolution, so the invention of the steam engine, which really changed science and changed society, there were lots of laws that were established. So Newton's laws, Faraday's laws, all of these ideas and understandings, but there was no actual utility or products or physical objects that was produced that society can actually benefit from. And so the scientific method was actually designed specifically as a means or a method or a conceptual bridge to move from principles, from those scientific principles, to a tangible or physical object that society can actually use that has some sort of utility. And of course, this was what particularly patent law is about. It's not just about, it's not about patenting a principle, which you can't do. It has to be some sort of usable form of a thing. Okay, I will just continue from there. Okay, so the Stationers' Company is just basically a name of a sect of the guilds that control basically the publishing industry in the UK at the time. So as I mentioned before, with patronage, the copyright would then be transferred to the guild itself, or the Stationers' Company, and the work itself would then be registered within the Stationers' Register itself. And when that happened, the Stationers' Company would then have a perpetual right to copy, which is also bequeathable as well. So it's perpetual means that it goes on forever. That right, that common law copyright at the time stays within the Stationers' Company. And also around this time, importantly, is when John Locke's Two Treatises of Government was published. So this was really the birth of the labor concept of intellectual property law. So the labor law thesis, which is basically that I've expended this much of labor, therefore I am entitled to proprietary interests or rights in my expenditure in some way. It's actually not the exact foundation because, as I mentioned, copyright and patent laws actually came before the Treatise of Government by John Locke. But after the publication of that work, and given its huge success, we had this idea that the ownership of the manuscript now molded into sort of an ownership of a personal right to publish this work, this valuable work. And eventually after time, the first codified statute was formed, the Statute of Anne, and that limited a copyright to 14 years. Now, obviously, the Stationers' Company had problems with this, considering that previously they had a perpetual right, and now it's been limited to 14 years. And so what they did, of course, was they challenged this in the courts, and they used the author as a tool in which to challenge this. They said, well, no, you can't do this. You can't limit it to 14 years because that's really bad for the author. You're taking away the author's ability to claim profits from his work. And that was actually the birth of authorship itself. So it was the Stationers' Company using the author as like a propeller in order to sort of claim back this perpetual copyright. And this is also very similar to the inventor's interest, which is also something that's been talked about quite a bit. Basically stipulating that, patent law is there to encourage human inventorship, reward human inventorship and whatnot. But really, the inventor's interest was just a political tool, which was created around the time of just after the French Revolution, just before the Great Exhibition. So the Great Exhibition was just like this huge gathering of different countries like Scotland, France, the UK, where each country was trying to demonstrate the different innovations that they have developed within their country as a means to, show off their powers. It's kind of like, we're showing off our different capabilities. Don't mess with us. This is what we are capable of. And now the fear behind that was like, if you're going to show off your inventions and what you're capable of, that also opens you up to the ability to being copied. So the inventor's interest was actually developed as a means in which to combat the way in which different countries can copy one another. And so that was really the birth of the inventorship doctrine as well in its modern form. Going back to the stationer's company, they did launch those series of cases in order to try and extend the common law copyright back to its perpetual status. And this was basically a claim in ideas, sentiment, style, etc. And there were a series of cases, Miller versus Taylor, quite a few others, in culminating with Donaldson versus Beckett, basically which said that you cannot actually have a common law ownership, because remember, common law copyright at the time was synonymous with common law ownership in ideas or patterns, simply because these are non-exclusive things and they must be free for society to test and utilize, just because that is for the good of society. It would also be impractical for the law to try and regulate in the space, simply just because it would be impossible for the law to determine who came up with an idea in the first place. How would the law preempt this other than what the parties would have to demonstrate in court themselves? But this just limits the way in which these disputes can happen. So in its modern form, style is one of the subjective elements of copyright, like Marina mentioned, human expression, human artistic expression. One of the big proponents, in fact, I would say the progenitor of style per se, was William Warburton, who was basically trying to protect some of his written work from being copied by a guy named Alexander Pope. And he argued that his style is that which identifies him in the work, and therefore that is what must be protected. And style is in the way in which he expresses himself. So it's not just the idea, but it's the identity. So id. And that comes in the shape of the grammar that he uses. Where does he place his punctuation marks, his quotation marks? What are sort of the linguistic devices and descriptive devices that he uses, the kinds of similes that he uses? All of these things reflects William Warburton's identity. And so that's how he linked himself to the work. And that was his proprietary interest, which was his identity. And he said that style or manner reflects the man, while matter reflects the world. And yeah, if you're interested about why there's a difference between patents and copyright as well, because really there shouldn't be, but there is. And it was really because of the idea between what is mechanical and what is organic. What is organic is found in copyright. What is mechanical is found in patent law, conceptually speaking. And it's because in patent law, the idea was that the parts come before the whole, meaning you have to assemble something to get to the whole. Whereas in copyright, the whole is there from the beginning. It's a lot to discuss because it goes back to lit theory, but this is how it was described as a time. It was also used by some of the English jurists. And it was also goes back to Aristotle, Kant, and Alexander Gerald. Okay,
Chandra,
so yes.
I'm so sorry to interrupt. Yeah, it's just that I looked at the time now and we just have 7 minutes left and we do have 11 questions in the Q&A. If you don't mind, can I quickly just address the questions in case anyone needs to drop off, and then whoever can stay maybe can stay on. I'm so sorry about that. Okay, cool. So thank you so much to everyone for engaging. I'm just going to go through the questions that were posted in the Q&A box. The first one we have is, I regularly use ChatGPT to write blog articles on wildlife for Safari Lodge. Is this considered plagiarism, and are the blogs protected from being copied? How can readers know that the blogs have been created using AI? So I don't know who wants to get into that. I think there's
I'll lead with that one. Just give me the three questions again. What the first is
the first was that the person was saying that they use ChatGPT to write blogs, blog articles for their Safari Lodge. Is this considered plagiarism?
So I would say the short answer to that would be it depends. So as I explained, the technology is intended to work in such a way that it creates content through independent decision making. So it is meant to create independent content using only what it has been taught. In other words, it's not designed to plagiarize and reproduce word for word. But we cannot exclude that from happening at all. We cannot guarantee that what is being produced by the AI platform is 100% original and new, and therefore does not potentially infringe on any existing material. The fact that you are asking it to create an article or a blog post per se would not amount to plagiarism. But unfortunately, the Copyright Act does provide for an infringement to take place if you are the person doing the restricted act, so doing that which is which copyright prevents you from doing. So let's take copying. If you are the person doing the copying, but also if you are the person causing the copying to be done. So the liability for infringement does go a little further than just doing the act. It does extend to also causing an infringement to be done. It is probably unlikely, and what you are receiving is probably okay to use. But like I say, we cannot guarantee or exclude any infringement. And then the second difficulty that arises to my mind is the fact that what it produces for you, it can produce for anyone else. So you do not have exclusivity over that content, which does, if I read the same blog post on two different Safari websites, I would question authenticity.
Okay, thank you for that, Marina. Next question is, what is happening in the US with the cases where creators are suing the LLM makers for scraping their content without permission?
The last time I read about that case, there were two. The one was nearly thrown out and they were provided an opportunity to supplement their paper. So the case was just not badly worded, it wasn't properly put together, and the judge afforded them a second round to bring it again. I do not know what has happened with that. The other one is the one involving the comedians. I forget their names. I think there are 3 or 4 of them. Now, they are part of the case that I referenced where authors were able to determine that their works had been included in a data set that had been used for training. Now, that case, as far as I'm aware, launched fairly recently, and there hasn't been any sort of discussion or outcome on that one. It should still be coming up for consideration. So we do not know what the outcome is there. I do know that there's a lot of academic discussion around that case and whether that infringement claim is likely to succeed. They have defenses in the United States that we do not have here in South Africa that turn on fair use. And the academic writers are saying that it's all going to come down to a fair use argument. But we'll have to wait and see. We have no outcome there yet, so we don't know.
Okay. Thank you, Rina. Next question is, Anonymous had asked, what's the SCA case? I'm not sure if you had mentioned in a Supreme Court of Appeal case, but...
I did. I will not be able to give you the full citation, but it is Haupt, H-A-U-P-T versus soft copy brewery something. But it's the Haupt SCA case.
Thank you. Okay, we have an interesting question here is, would the person funding the computer-generated work be considered an author or owner?
With the first person funding the computer-generated work.
Yeah. be considered an author or owner?
That is a good question. Not to my knowledge. So the Act states that an author will be the first owner of the copyright, unless certain exceptions apply, and those exceptions are very limited. One of those exceptions is where a work is instructed and paid for, right? But that instruction, we call it the commissioning exception. The commissioning exception is very limited. It's limited to a finite list of works, which include a photograph, a sound recording, a film, a portrait, and a gravure, not a computer-generated work, to my knowledge, which means only for those exceptional circumstances, sound recording, film, photograph, and a portrait, where you instruct the work to be created and you pay, that's when copyright ownership shifts. Apart from those works, copyright ownership never shifts. So if you instruct, for instance, an external graphic designer to create a logo for your business, that's an artistic work that is not caught up in that exception. So even though you're instructed and you pay for it, you do not get the rights of copyright ownership through that commissioning. So the answer should be no.
Thank you. And now we have hi. So this would mean that the user adding knowledge into AI would be considered an owner author should sufficient effort and skill be introduced.
Yes. But like I said, will definitely come down to a factual question. How much was, put in? Because like I say, to my mind, a single text prompt, give me an image of the map of Africa in a futuristic style. Would that be considered sufficient skill and effort to lead us to original work that qualifies for copyright protection, versus something, and I've seen this play out, and that's why I use it as an example, versus something like a software developer, somebody with that knowledge, with coding knowledge, sitting and sort of engaging the AI in getting to functionality until they are happy with the end result, and it's something that can actually be implemented.
Yeah, it also depends on the AI's capability itself, whether it's just using a straight deductive knowledge, or if it's actually implementing some sort of creativity that isn't just straight 1 + 2 = 3.
Okay. We have a question, well, a question with commentary. It's please talk about how we know whether the original creator, whatever is being created is or generated is protected.
Are we talking about the, so we again talking about the material that was created by the AI platform, by the user? So that assessment essentially will come down to the same questions, and that is, who do we consider to be the author of the computer-generated work? And as I mentioned, there are two potential arguments there. One is for the developer and one is for the user. My personal opinion is more likely the user. It's just the developer is very far removed from the end result. That makes it very difficult for me to see an argument in favor of the developers of the AI. So it's probably more likely the user. And then the question becomes, what did the user do? And whether what the user did can qualify as being sufficiently original, sufficiently expending time and effort and skill or knowledge or intellect or creativity, whatever the case may be, relevant to the assessment to make the end result generated by the AI an original work. If it's not an original work, if we can't satisfy that test, if we can't pass that bar, then it will not be protected by copyright. And that is typically where I'm seeing the potential for copyright protection to be excluded arise. It's going to be, it should be hard to meet the originality criteria.
I'm terribly sorry. I know we are slightly over time and we still have 7 questions. So I'm just going to take 2 more if you don't mind, Warina and Mishandra, and then we'll try and address the others in the chat box. So the first one is, any thoughts on the click wrap agreements one signs when using AI tech like ChatGPT? In short, any thoughts in respect of position, rights, and risks between user and service provider?
That's an area that we did not even get into discussing at all, and that is what contractual arrangements are in place, or at least have sought to be put in place between the service provider and the user. I know some of these platforms, for instance, we are discussing the issues around ownership and who owns the content generated, or at least the material generated by the AI, but in some of those platforms, the terms and conditions specify that the user will own it. So it really depends on the platform. It really depends on the service provider, the terms and conditions that have been put in place. And then an added complication is that even though the terms and conditions may say so, it doesn't mean that legally that would be the position in every country. You must remember that copyright is a territorial right, and the requirements for copyright to subsist, the subsistence of copyright and the ownership of copyright needs to be determined according to the laws in force in each country, really. So we can't even give a blanket answer for sort of, a global answer. It's not going to be possible. But the short answer is, I guess, you can go and assess, at least look at what terms and conditions are in place for the service provider that you are using.
Thank you, Marina. And then lastly, trade as names, do they need to be registered with SIPC? If not, how can a person search thoroughly to ascertain that the name is non-existent?
Trade names, just the first part.
Well, it says trade as names, but I suppose they mean trade names. Do they need to be registered with SIPC?
Well, they're two names, let's call them names, that can be registered at SIPC. The one is, of course, the company name register, and there you can register defensive company names. But I think what would be more appropriate would be the registration as trademarks, which is also governed by SIPC. And that's, in accordance with the Trademarks Act and all of the requirements around trademark registration that become applicable there. SIPC does allow a public search function that you can use to see, to try and search and see whether something is available or has already been taken. The publicly available search function is limited, and if you want to have a fuller picture, and make sure you cover all bases, because it's got trademark system, it's got a 45 class system, it's that's a whole another conversation. But to cover yourself, to make sure that you've done a thorough search, it would be best to do a trademark search or use a trademark search service, such as intellectual property attorneys. Otherwise, you are quite limited to what is available publicly on SIPC's website, but there is availability. You're not just left with nothing. Same on the company's register side. So, and then internet searches, it is best to do a due diligence, sort of as far as you can, as widely as you can, to make sure that you're not encroaching on something that exists already. But searching would certainly be very important before you adopt a trademark.
Thank you, Brina. Okay, so that brings us to the end of the Q&A segment and our discussion today. Clearly, 1 hour is not sufficient for the topic at hand. And this is something that is going to be on top of everyone's mind and discussed at everyone's social gatherings for a long, long time to come. I would like to extend another thank you to Verena Griffiths and Mishandra Naidu for sharing their knowledge and insights with us and for your time. To our attendees, we truly appreciate your active participation and thoughtful questions. Your engagement is what makes these sessions valuable. I do apologize that we weren't able to address all the questions posted, but we will try to make provisions for them. So please keep an eye out for future webinars, and a reminder, the recording will be made available to those who consented to receive marketing material. On behalf of LexisNexis and our panelists, thank you for joining us today. Stay safe, and we look forward to welcoming you to our future events. Thank you. Goodbye.